May 21, 2019. The trial ended in a courthouse that smelled faintly of coffee and old paper, a building whose corridors held the echo of many private disputes made civic. He stood at the defendant's table beneath fluorescent light that flattened the face he had always used to negotiate his way back into the household, contrition as practiced choreography. He apologized in sentences he had spoken before in kitchens and living rooms, phrases with habitual force. I'll get help. I'll be different. I'll rebuild. Once, those words had worked like a bridge, rerouting suspicion into forgiveness. In that courtroom, under the formality of sworn testimony, the staccato of the court reporter's keys, and the impartial weight of a judge's gaze, those phrases sounded rehearsed, their scaffolding showed through. When the last witness left the stand and the jurors filed out, a county probation officer came forward to assign him a caseworker. Paperwork began to multiply: court orders, intake forms, dates stamped in a ledger that would come to chart obligations, restrictions, and inspections for months that followed. It was the beginning of a new, bureaucratic chapter in a story that had been lived in domestic gestures for years. June 2019. The caseworker's first visit took place in a municipal building whose walls were hung with framed certificates and procedural posters reminding citizens of their rights. She entered with a practiced patience the way an official carries an emblem: steady, measured, and professional. She was a buffer between the intimate damage and the machinery of state oversight. He reported as required, negotiated conditions as if bargaining could replace responsibility, and attended classes intermittently. When old reflexes returned on certain days, he would slip away early. Those absences were small at the time. Unremarkable unless you were tracing behavior as an archaeologist traces strata. One omission here, one unexplained departure there, accumulated like erosion. What seemed trivial in isolation later became legible under the scrutiny of records and cross-reference dates. 2010. A broader legal context framed these private upheavals. For nearly a decade, the nation had been responding to elder exploitation as an institutional challenge rather than merely a string of personal tragedies. The Elder Justice Act of 2010 had been a landmark, federal recognition that financial abuse and neglect were systemic problems, not merely family misfortune. It created pathways for funding, investigation, and cross-agency cooperation, giving adult protective services and law enforcement new tools. But legal statutes can only make a map of wrongdoing. They cannot always compel people to step onto that map. Social norms, an emphasis on family privacy, the stigma of accusing kin, often left elders without the kinds of records prosecutors need. That ambivalence threaded through the next chapter of my family's life, where law and reluctance met at the kitchen table. November 10, 2019. Late on a Sunday night, at 11:42 p.m., the porch camera recorded him on the visitor side of the front door. The timestamp, stamped in white on the bottom corner of the file, felt like a primary document, an impartial marker anchoring a contested memory. He knocked beneath the sodium lamp in a thin coat unsuited for the evening's chill, adopting the cadence of contrition he had practiced for years: a measured pause, an imploring look, a weary timbre. It was a performance that had, in other houses and other moments, dissolved resistance. I opened the door with court paperwork heavy in my hands and a patience that had been hardened into architecture. I had watched him reduce the household to ledgers and liabilities. I had learned to read gesture as strategy. He begged, he pleaded. A neighbor, unsettled by the late visit and the tone in his voice, called the police. Officers came. They asked him to leave. He stormed down the driveway, too large for the shame he attempted to carry. The porch camera captured his face in that split second when the performance failed, eyes wet, jaw tight. Then it recorded his retreat into the dark. That recorded file, labeled with its minute precision, became a hinge in our chronology, a piece of evidence that would later be played in small rooms and larger hearings, a timestamp that anchored testimony and memory. Late 2019 through 2020, the months that followed were not a steady decline but an iterative reshaping of domestic life, repetitions of small cruelties and tentative remedial acts that altered the weather of our house. My father's occasional forgetfulness migrated into hazard. Keys multiplied like insoluble questions. He missed medications and appointments. He needed a pill organizer, notes taped to the refrigerator, and an interrupting hand if he tried to drive. My mother, who had long been the steady center of household decisions, withdrew into long periods of staring out the window, hands folded as if counting days. I hired a caregiver for 3 days a week, printed bright calendars and taped them to the fridge, and became the executor of errands and medical check-ins. The unglamorous daily logistics that have no immediate climax but which, day by day, amount to care. Each small intervention was an attempt to stave off the slow march toward more irreversible loss. December 2019. A guardianship hearing in a modest courtroom formalized what had been practical for months and tightened my legal responsibilities. The judge named me keeper and gatekeeper, medical records, bank statements, decisions that used to be negotiated informally over chipped plates now required forms, signatures, and occasional notarization. With guardianship came a regimen of monthly accountings, checklists, and annual reviews by social workers who measured risk with a clinical detachment. I learned new vocabulary: undue influence, chain of custody, conservatorship, and the contours of adult protections, when to invest, when to conserve, which documents could be signed and which required court permission. Guardianship law had become a contested field in public debate. Advocates argued that it could both protect and, if misapplied, strip autonomy. That tension lived in every form I was asked to sign. The legal framework promised protection, but it also transformed intimate decisions into administrative tasks, forcing private grief into public files. March 3, 2020. Months after the trial, he posted a set of vintage silverware that had belonged to my mother's grandmother on a community bulletin board app. The pickup details were written in his hand. A neighbor sent me a screenshot the next day with 3 words: "Is this yours?" I called the number and pretended to be an interested buyer. He answered with the smooth, practiced cadence of a salesperson, the kind that can mask culpability. I kept the call brief, forwarded the screen grab to the detective assigned to elder exploitation cases, and watched the law begin to map a path through the small transactions I had noticed but had trouble proving. March 12, 2020. The detective traced a pickup through a convenience store receipt and a rideshare app to an address linked to a friend. He treated the screenshot like a breadcrumb and followed it until an arrest could be made. The second time the police took him from our house, this time for possession of stolen property, the blotter read like confirmation of what we had feared for years. Small, repeated transactions that had once seemed private missteps combined into criminal acts that could be recorded, filed, and prosecuted. The arrest felt like a ritual confirmation, a paragraph in a public ledger we had been living toward and dreading. March 2020 to late 2020, the legal events coincided with a larger historical emergency. As the coronavirus pandemic swept across the country in early 2020, courts slowed and access to in-person services for older adults declined. Shelter-in-place orders turned everyday routines into legal arithmetic. Telemedicine replaced clinic visits, libraries closed, support groups were suspended. Pandemic restrictions compounded caregiving problems. Phone lines lengthened, administrative delays became institutional habit. Federal agencies and nonprofits warned that scams would increase and that elders isolated from regular social contact were more vulnerable. In this context, physical proof and presence increased in value. A time-stamped video or a file backed up in the cloud could mark the difference between prosecution and a story that faded into rumor. Summer 2020. Evan's legal troubles culminated in a plea entered in a courtroom physically rearranged for social distancing. He admitted guilt to a consolidated set of charges, counts that reflected the variety of offenses we had been watching: theft, attempted fraud, and one count related to falsifying a signature. A clerk recorded his plea into the official record. For the state, the plea closed a thread of litigation. For the family, it served as a punctuation we had long expected. His sentence included community service, supervised probation, and restitution that would likely take years to fully satisfy. The law quantified harm, hours of service, financial restitution, mandated behaviors, but could not restore the invitations revoked by rumor or the ease of trust we had lost. Court orders could not unring the bell of suspicion reverberating through relatives and neighbors. September 24, 2020. In the fall of that strange year, I began a small group at the public library that met Thursday nights under a fluorescent light at a folding table. The initial plan was practical and modest. Teach people how to protect elders, how to document thefts, how to use surveillance responsibly and ethically. The first meeting was sparse: 3 chairs, 2 notebooks, a thermos. But the need in the room was immediate. The group quickly became more than a how-to. It was a civic response to patterns visible in other households. People who came were not identical. A man described finding strangers' checks in his mother's checkbook. A woman spoke of a brother who had moved in and later emptied the house of small treasures. Some attendees regarded cameras as essential, others feared that private lives could be turned into footage to be judged. We argued over the meaning of consent when memory was fading, whether a clip should be shown to a reluctant neighbor, and at what point a caregiver's sloppy bookkeeping crossed into criminal conduct. October 2020, word of the footage and our efforts spread. People began calling from neighboring towns. A woman 2 towns over asked how I had used footage in court. A man whose elderly aunt had been coaxed into signing documents wanted to know a notary's duty. I told the story so often the specifics settled into a pattern, disbelief curdled into resolve. The cases that came to me were not identical, but they shared a logic, petty cons leveraging the social unwillingness to look closely at loved ones' behavior. October 2020 to June 2021, the library group evolved into a small civic node. We invited guest speakers whose expertise bridged law and practice. An elder law attorney explained the difference between a durable power of attorney and guardianship. A forensic accountant demonstrated how small frauds moved through accounts unnoticed. A former bank manager described the red flags that often go unheeded. We held workshops on chain of custody, on securing footage, and on how to approach a neighbor about suspected theft. The discussions were practical and morally intricate. From these meetings we crafted working principles: secure footage with encryption where possible, seek informed consent when feasible, limit sharing to official channels when legal matters are involved, and label archives clearly with timestamps. These were not grand solutions. They were scripts people could follow in moments when they felt they had none. There were more immediate, dramatic confrontations too. One attendee played a clip of a family friend rifling through drawers while an older woman was distracted. When the friend was confronted with the recording, the behavior ruptured and an explanation scrambled into denial. Another attendee used video evidence to recover a box of letters and a brooch. The items were placed in the police evidence locker until charges could proceed. These modest recoveries mattered concretely. Often the real triumphs were quieter: a daughter deciding to read bank statements for recurring odd withdrawals, an older woman learning to label accounts and ask for statements monthly. Small acts of attention multiplied into modest defenses. The detective who had traced the silverware worked with forensic patience. He asked for dates, times, and other incidents I could recall. Law enforcement builds cases by connecting dots. Each item sold, each falsified signature, slid like a bead on a string toward consequence. His methodical approach made the case feel inexorable, a sequence of small violations that, when documented, demanded a response. He explained, repeatedly and plainly, that elder exploitation rarely takes the form of a single theatrical theft. It looks like a lifetime of small compromises and a handful of larger betrayals. Early 2021, guardianship oversight, which had begun as an emergency intervention, turned into a new form of labor. Each month I produced accountings showing how funds were spent: groceries, utilities, medication, caregiving wages. I sat with bank managers and social workers and explained line items. The system treated caregiving as administrative as much as moral. Social workers arrived with forms and pens, and oversight transformed private loss into a dossier that could be documented and audited. The process was necessary and disorienting. It required converting memories into data and feelings into footnotes. There were moments when the ledger's bluntness felt like a betrayal of everything intimacy had once signified, but the ledger also kept the household honest in ways silence could not. Surveillance, I learned, was a limited technology. The cameras recorded motion, not motive. They captured expression but not interiority. They showed him shaking in an interview room and, in another clip, my father laughing at a joke he had told himself. They showed my mother placing a plant on the windowsill and then returning to a low-grade attention that can easily be mistaken for indifference. Those images complicated the neat moral arcs I had drawn in private. The same footage that helped establish patterns also but I understood that social and medical interventions were necessary complements that surveillance could not substitute for. There were administrative victories that felt significant in their procedural way: monthly accountings accepted by the court, heirs receiving returned items from evidence lockers, successful charges filed. There were social losses that felt irreparable: relationships severed, a daily chorus of voices reduced to quieter conversation, empty chairs at Thanksgiving and other holidays. The house settled into a rhythm that was protective and austere, full of routines meant more to prevent theft than to cultivate warmth. January 18, 2022. In the small hours of the morning my father died. He passed quietly, my mother holding his hand, the type of private exit that makes no headlines because it is ordinary and inevitable rather than sensational. Evan did not attend the funeral. He did not call. I organized the burial, read the words I had chosen, and watched attendees leave under a sky that had the practiced color of civility. Standing at the graveside, I felt the strange culmination of an argument that had carried us for months and years. Inheritance is often less about money than about the stories we owe one another. The camera had preserved crucial records of what had happened in the household. It could not preserve the man who had told countless family stories over decades. After the funeral, the house felt like a stage deliberately left empty. Dust collected in corners like judgment. Coffee ring stains marked the table. An old plant stain from a holiday mishap remained on a carpet square. I walked the rooms and let the cameras keep watch, their blind mechanical eyes rolling across familiar furniture and small domestic detritus. Watching the feeds felt clinical at first, loops of the living room, the kitchen, the porch. In a clip recorded the day after the burial, my mother sat in the recliner with a doily on her lap and looked at nothing. The concentration on her face implied an effort to hold onto the outline of what she had lost. I watched that footage until the light faded and the house folded into night. To some, those cameras were an affront, a way of turning family life into a forensic exercise. A friend said, bluntly, that I had weaponized technology against family. The phrase stung. I had to own that, in a sense, I had weaponized evidence, but the weapon was aimed at preventing further harm. Where others saw coldness, I saw a ledger of truth that could keep future losses from being repeated. I learned to tolerate other people's discomfort as a cost of protection. The argument that families should manage these matters privately sounds plausible until secrecy calcifies into patterns that become impossible to challenge without documentation. In quiet hours I watched footage not for evidence but for memory. A simple video of my father making coffee in the kitchen has no legal value, yet it serves as an archive of tenderness. He pours with exaggerated seriousness, consults a dog-eared pancake recipe, hums a tuneless melody. My mother, towel in hand, corrects his grin. They do not know the cameras are watching. Those clips insist on a stubborn truth. Life had once been ordinary and loving beyond the legal ledger. The recordings preserve ordinary gestures that the law, with its cold categories and counts, cannot capture. Strangers continued to come through the library door seeking advice. Each retelling reopened old wounds in me, yet the act of telling also helped heal them a little. A woman whose sister had lost money to a neighbor later told me that the camera footage made the difference between a story that would have faded into rumor and a case that could be prosecuted. An older man who had begun to notice small but recurring withdrawals in his mother's account learned to label accounts and to compare statements monthly. These were slow victories, the kind that rarely made newspaper headlines but mattered in the rooms they happened in. The detective's patient work remained instructive. He wanted firm dates, times, names. He wanted what lawyers call particulars. He wanted to reconstruct the method by which loans and gifts had become suspect transactions. Sometimes his inquiries forced me to look harder at memory and to be precise where feeling wanted to be generous. He explained repeatedly that the law is good at naming offenses and counting restitution. It is less adept at reconstructing trust. That reconstruction is social work, family therapy, and long, uneven conversation. There were evenings when I replayed the clip of him leaving and felt the image sharpen into something I could hold without falling apart. He wore gloves, hands clenched, his gait a half-step between shame and fury. The porch light framed the moment, his shadow stepped into darkness, and then the frame went empty. That recorded moment is a photograph in time that contains 1,000 unnamed things. I keep it not to humiliate but to witness. Witnessing, I learned, does not amount to revenge. It opens the possibility of reckoning that relies less on fragile memory and more on record. If the cameras taught one lesson about justice, it was this: justice is procedural and incomplete. Courts can sanction and prescribe, but they cannot restore the slow corrosion of trust that accumulates over years. Orders returned some money, assigned hours of community service, and placed supervision that the state could measure. They created a public record, a ledger of entries that gave names and times to actions. The law could show here is what was taken, here is what was returned, here is a notation that someone had attempted to take more than money. It could not return the day the house hummed with ordinary assumption. So I kept the cameras. I kept the house. I kept going. The ledger of small actions continued to fill. Some entries read like triumphs, a recovered heirloom placed back in a locked drawer, a successful prosecution that deterred subsequent theft. Others read like losses, severed relationships, long conversations left unsaid, the way a hallway once filled with voices became a corridor of smaller talk. There are no tidy reconciliations, only the ongoing work of living within the consequences of choices made long before anyone could name them. The blinking LED on the porch camera remains a small, honest light. It does not claim moral authority. It is evidence and, in a modest way, comfort, a reminder that someone is watching not to voyeuristically judge but to witness. Witnessing paye pour lui. It requires holding contradictory images at once, the man you loved and the man who took advantage, the father who laughed and the father who was deceived, and it demands stubborn record-keeping alongside tenderness. As institutions refine their responses to elder exploitation, through legal reforms, advocacy for better guardianship safeguards, and more targeted training for financial institutions about red flags, neighbors and families continue to do the work statutes cannot fully cover. We document, convene, and teach one another how to preserve records, how to speak to banks and detectives, how to file complaints whose weight can be measured. We learn the language of protection, undue influence, chain of custody, conservatorship. We draft modest scripts for days when we have none. Those civic practices matter because laws without attentive witnesses often remain words on paper. There is no tidy moral, no clean reconciliation. There is only the work of living within consequences, of watching the ledger grow and of trying to repair the soft fabric of family with slow stitches of attention. The camera's record lets us argue about what happened without relying entirely on memory. In a life where memory can be unreliable and intention slippery, that is an imperfect mercy. One I keep as the seasons turn and the small entries keep adding to the ledger of our days. The attempt to transfer the house did not arrive as a sudden bolt from the blue. It arrived in the small, freighted gestures the cameras had already been trained to notice. Visits that lengthened from an hour to a day, afternoons when Evan brought packages and left with wrapped paper, the careful repositioning of mail and ledger books so that certain statements did not reappear on the kitchen table. The chronology matters. After January 18, 2022, when my father died, the rhythm of the household changed in ways that were both obvious and subtle. Grief makes people conspicuously small, and it made my mother, in particular, vulnerable in ways that friends and professionals could describe clinically but family members felt personally. February and March of 2022 are months I watch often, because they contain transitions. On March 10, 2022, a clip shows Evan arriving with a paper folder and a small black notebook. The porch camera timestamped the knock at 10:42 a.m. and filmed him pushing the screen door, hat in hand, moving with the same half-step I had seen the day he left months earlier. He brought a man with him this time, a notary, by the look of the badge clipped to his belt. The living room camera picked up their voices at a low volume. The audio is thin but intelligible in parts. My mother sat on the sofa as Evan leaned over to show her a sheet of paper. He was patient, his face softened for the camera in a way that made me feel animals think. He was performing caretaking. The notary moved closer and moved the papers in a way that suggested procedure rather than scrutiny. What the footage captured mattered less as a dramatic tableau than as a sequence of causal steps. My mother put her hand on the line and signed. The camera caught her pen pausing, the tremor in her hand, the way she looked up at Evan as if searching for instruction. Minutes later, the footage shows Evan gathering the papers, tucking them away into his black folder, and standing to leave with a particular calm. When the porch camera recorded the shutter of the screen door closing, his shadow fell long across the steps. The axis of the house, the ledger of whose belongings were where, had subtly shifted. By the time I noticed the change, it was already layered into other complexities. The estate's informal accounting had begun to show odd entries, small transfers between accounts that did not correspond to bills, and a pattern of unfamiliar names on call logs. I had been compiling a habit of surveillance because I had already suspected more than I could prove. The detective had taught me how to find the particulars, dates, times, signatures. The camera footage supplied those particulars. On March 21, I made the decision to act not just as a witness but as a plaintiff. I filed an emergency petition in probate court seeking a temporary restraining order and an accounting of recent transfers. The petition included printouts of the camera timestamps and a brief affidavit describing the March 10 encounter. The detective's willingness to authenticate the footage mattered in court. Judges are, by vocation and necessity, cautious stewards of evidence that mixes the intimate with the procedural. The judge assigned to the case asked hard questions at a hearing on April 28, 2022. Was the footage unaltered? Could metadata prove the clips were continuous? Had the notary followed protocol? Had there been independent witnesses to the signing? The detective brought a forensic analyst who exported the clips, preserved the chain of custody, and testified about checksums and file integrity the way a historian describes the provenance of a rare manuscript. That testimony meant that what had once sat in a private feed could be treated as public proof. The notary, when subpoenaed, gave testimony that was careful and thin. He offered the formal language of procedure, but under cross-examination the inconsistencies surfaced: a missing entry in the notary's ledger, a signature that did not match other samples, and a recollection that wavered on where he had placed his stamp. For the court, those gaps were more than clerical errors. In elder law practice, form often masks intent. A notary who does not observe a principal sign or who backdates a stamp can turn a private preference into an unassailable legal instrument. The camera had caught the informal moment in which a line was formed and then signed, and the court could now scrutinize whether that moment had been executed with the safeguards that protect the vulnerable. On May 16, 2022, the court issued a temporary freeze on any transfer of title pending a fuller hearing. For my mother, the freeze was both relief and insult. Relief because it meant a procedural barrier against a sudden displacement she would not understand, but insult because it treated her like a subject to be restrained. I accompanied her to the hearing. She sat with a knitted shawl around her shoulders and looked at the judge as if she were listening to a neighbor give weather reports. I read the transcripts later and found my own voice recorded, simple declarative sentences that described what I had seen. When I read them aloud in the quiet of the living room, the cameras angled over, I felt again the oddness of having private life reframed by the formal language of court. The fuller hearing in August 2022 became the place where private footage acquired public force. The clips were played in a courtroom at a pace that allowed juried eyes. Here is the knock, here is the folding of the paper, here is the tremble, and the notary's ledger was placed under a bright lamp. The judge's clerk scrolled through a bank of documents, 2 deeds with different dates, a stack of checks, a small handwritten note that said, "In my mother's scattering hand, Evan House." The legal question was not, ultimately, whether Evan had cared for my mother. He had indeed brought groceries and mowed the lawn, but whether the transfer of the house had been procured through undue influence when my mother lacked the capacity to understand or to resist. Undue influence is a legal category with social teeth. It requires a showing that one person had the opportunity to exert pressure and that the resultant act was inconsistent with the natural disposition of the testator. The court heard testimony from neighbors who described a pattern of visits, from the bank officer who noticed withdrawals that did not conform to my mother's usual behavior, and from a family doctor who, reading records, expressed concern that my mother's cognition had declined in the months leading up to the transfer. That professional testimony gave shape to what the camera had registered, a pattern of care that had at spots become control. In October 2022, the probate court's written opinion set aside the transfer on grounds of undue influence and irregular notarization. The opinion was technical in language and thorough in citation. It built a bridge between the human story and the letter of the law. The court ordered a full accounting of estate transactions from the prior 6 months, appointed a temporary conservator to manage my mother's finances, and directed that the house remain part of the estate until a later hearing could adjudicate final distribution. For a moment, the ledger of transactions had been forced to reconcile with memory and to face accountability. The social consequences were immediate. Evan, whose relationships had already frayed, felt publicly accused and retreated further into silence. Some relatives lined up with him in private messages that read as lamentations. He was trying to help, while others, who had seen the footage at family viewings I organized to be transparent, addressed him with cold civility. The cameras, which had once been private witnesses, had become instruments that changed how people addressed one another. There is a strange double effect. Evidence clarifies but also deepens estrangement. The yard that had hosted small neighborhood games and barbecues found fewer guests that summer. Invitations were sent by some but not accepted by others. The house was, for months, an island. The administrative work that followed could have been written as a ledger: letters to tax assessors, forms to insurance companies, conversations with the local housing authority about deferred maintenance. I learned how to read the municipal codes that governed property transfer in our county, how to fill forms for a conservator's bond, and how to explain to a compassionate but bewildered clerk why a court order required locks to be changed and a doorbell camera to be installed where none had been before. In December 2022, I moved heavy things by myself at 2 a.m. because a contractor would only come during daylight. The cameras recorded me hefting boxes, and an assistant at the bank sent a note that said, simply, "Thank you." Those small, procedural tasks, boring, granular, essential, became the new public work of stewardship. My mother moved into assisted living in February 2023. The move itself has a date that matters to me, not because it is a legal milestone, but because it was the point at which the house shifted from being a living presence to being an artifact of memory. On February 19, 2023, I closed the door on the bedroom where my father had slept and knew, with the full weight of the camera's memory, that the house would no longer be live in the same way. Some of her things went into storage. Others went to family members who took them because the items carried stories too large for a box. The cameras still watched the rooms, but now their purpose included archival intent, recording a house as it settled into the administrative liminality of probate. Evan's trajectory after the court's October 2022 ruling was small and complicated. There were more meetings with probation officers recorded in the public docket, and the detective's patient watch continued. In some ways the legal system's reach narrowed. It could punish theft, it could set aside transfers, it could recommend restitution and supervision. In other ways its reach broadened as judges, social workers, and bank officers began, at least in our county, to discuss tighter protocols for noticing odd transactions from elder accounts. The case prompted a local bank to revise a policy that required in-person verification for large cash transfers from accounts whose owners were over the age of 80. A city council member referenced our case in a public forum on elder abuse in May 2023 and included a clip of the porch camera as part of a presentation about red flags. The clip, stripped of identifying audio, had become a civics lesson. There were also moments that felt less like legal triumphs and more like moral reckonings. At a mediation in July 2023, parties exchanged apologies that landed clumsy in the room. Evan said, in a voice that cracked, that he had been trying to hold onto a family that felt like it was slipping. My mother wept and said she had wanted to make sure her house stayed within the family at a time when she feared being alone. The cameras had recorded the fear and the calculus that came from it. They had also recorded small tendernesses. Evan sitting by my mother's side as she read letters from a friend. The point of the footage, I increasingly thought, was not to present an unchanging moral portrait, but to show humans in their messy, ambivalent acting upon one another. Even when the law addressed an injustice, it did not magically restore the lost intimacies. The year that followed became one of repair and of tedious, necessary work. I instituted a formal visitation schedule for relatives, archived footage in a legally secure server, and paid for monthly professional cleaning to stave off deterioration. I learned how to request redaction of footage when privacy concerns were legitimate. Some clips had nothing to do with litigation and everything to do with comfort. There were grandchildren who had old home videos that now coexisted with the camera's more forensic clips. The house, in the camera's unblinking eye, contained both the evidence of harm and the traces of love. More broadly, the case forced a reflection on the ethics of domestic surveillance. I was not comfortable being the person who had made home into a record, but I had convinced myself, consistently and sometimes desperately, that the camera's ledger was preferable to secrecy. There were evenings where I unplugged the living room camera and watched old footage on my laptop until the feed blurred into memory. Other nights I left it recording because I feared I might miss a small but crucial gesture. Friends who visited often asked if I worried about becoming numb to the footage, about losing the effective sense of memory to an endlessly looped recording. I did worry, but the footage taught me a different kind of attention, a discipline of noticing the small ways people express consent and the small ways they do not. In court filings and in conversations with social workers I began to draft not only protests but proposals. If the cameras had done what they could within a fraught family situation, What systemic changes might prevent similar harms elsewhere? I wrote a letter in August 2023 to the statewide elder advocacy group recommending an easy checklist for bank staff, asking whether an account holder had a co-signatory, whether a care provider was listed, whether there had been recent large withdrawals, whether a notary had completed a ledger entry. The group published a version of that checklist in December 2023 and hosted a training session for local credit unions in March 2024. The ledger of small bureaucratic victories accumulated next to the ledger of social losses. Thanksgiving 2024 found some long-standing relatives still at a distance. Some invited me to dinners where we did not speak of the cameras. Others asked about the footage as if it were an artifact of their own history. There were moments of small reconciliation. An aunt who had once refused to see Evan stopped by the house in late 2024 and placed a hand on my mother's shoulder and said, simply, "I'm sorry for not coming sooner." The cameras recorded the visit in an unremarkable clip, a single 10-minute file that later felt like a small salve. Still, the work remained ongoing. There were motions to be filed, accountants to consult, and an attic full of boxes whose provenance required sorting. The courtroom decisions had given me legal authority to manage certain affairs, but they did not disentangle decades of habit and expectation. The cameras, for all their clarity, had not produced a moral ending. They had instead given us a record to live within, a ledger that could be used to argue and to heal with equal difficulty. As the seasons turned once more, I continued to keep the cameras running, not as a final answer, but as a way to ensure that future actions could be seen, dated, and understood by those who would come after us, and I kept working toward a resolution that would be measured in patience as much as in filings. Spring bled into summer of 2025 with a kind of procedural patience that felt, at once, punitive and merciful. The court docket, which had been a jagged ledger of motions and emergency orders since October 2022, settled into a rhythm of scheduled accountings and procedural confirmations. On March 12, 2025, the conservator filed a final 6-month report that itemized repairs, property taxes, utilities, and the costs of maintaining an active archival camera system. The report, dry in its language, precise in its receipts, rehearsed the chronology that anyone who had watched the footage already knew. The porch camera first recorded the unusual visit on an afternoon in July 2022. The bank officer flagged the withdrawals in late August. Our family doctor recorded cognitive decline in notes dated September 2022. The court's calendar entry for June 2, 2025, scheduled a hearing to determine disposition of the house itself. That date was a pivot point the way court dates rarely are in private life. It promised a formal transformation from liminality to settlement. Between March and June, the work required no theatrical energy so much as repeated, exacting effort. I sat with the conservator and we reconciled ledgers line by line. I supplied invoices for the December 2022 locks and for the doorbell camera purchased because the probate court had insisted the property be secured. The conservator's accountant, a patient woman who preferred numbers to narrative, pointed out that selling the house would remove an ongoing liability for property tax, but it would convert a sentimental geography into a check that the court would distribute according to statute. We scheduled a home inspection for April 28, 2025, and the report that came back catalogued creaky floor joists and a roof that, while not imminently failing, would be costly over the next decade. Those are the sorts of prosaic findings that shape moral choices. A house demands maintenance and provision, and sometimes the obligation to maintain exceeds the estate's immediate capacity. Evan's life, too, continued to unfold in small increments that bore the invisible marks of the camera's testimony. He had moved into a one-bedroom apartment in late 2023 and had enrolled, haltingly at first and with the prompting of a probation officer, in a community program for anger management and financial literacy. In the spring of 2025 he entered into a mediated agreement with the estate, a restitution plan that required modest monthly payments and a schedule for sustained engagement with a local elder care support group. The agreement was filed in the probate docket on May 15, 2025, and the record of his signature there, placed beside the bank officer's earlier notes and the doctor's chart entries, felt to me like a continuing attempt at repair, however tentative. I do not mean to suggest that restitution heals everything, it does not. But it can redirect harm into an account that acknowledges cost. For Evan, that acknowledgement came with conditions. He would continue to avoid direct contact with my mother, he would provide monthly reports to his probation officer, and he would attend family mediation sessions offered pro bono by a restorative justice group downtown. The cameras had shown a version of his care and control. The court and community programs attempted to channel his energy toward accountability. On June 2, 2025, the hearing convened in probate courtroom 3B in the county building that bore the same sandstone columns my father once admired when he taught local architecture students. The judge, who had read the record closely, approved the conservator's recommendation that the house be sold and the proceeds be used to reimburse the estate for conservatorship expenses and to fund my mother's ongoing care. There was no theatrical moment, no gavel-bang epiphany, but a careful recitation of receipts and an order that specified a timeline for listing, appraisal, and sale. The judge also issued a narrowly tailored order allowing the conservator to transfer redacted clips to accredited training programs and to local elder advocacy groups for educational use. Privacy protections were to be observed and names redacted. In a way that might have seemed paradoxical to observers who assumed footage is either evidence or spectacle, the court treated the camera's materials as pedagogical artifacts, useful, but not to be consumed as gossip. The listing went live on June 29, 2025. The real estate agent, recommended by a neighbor who had once introduced my parents at a community potluck, took photographs in the late morning light and asked that the archival cameras remain active until closing to protect the property during showings. For weeks there were open houses and potential buyers who walked the same paths my family had walked for generations, reading paint swatches and imagining where a third bedroom might be. Each showing left a small metadata trace in the camera files, a cropped face redacted for privacy, a blurred conversation, an inventory note scrawled on a flyer. In July, a couple from a nearby school district made an offer within the range the conservator and I had calculated. Their offer closed in mid-August 2025. The sale did not feel like resolution so much as transformation. The house's material presence shifted into a financial instrument that would pay for nursing care, for the conservator's fees, and for distributions the court would make to heirs under the law. That August the county's elder advocacy group published a report that acknowledged the case by anonymized citation and recommended systemic reforms. It referenced the bank policy revision of late 2022 and the statewide checklist published in December 2023. It credited the footage's pedagogical use in training sessions in March and April 2024 and in seminars that ran through the spring of 2025. The report proposed a statute, introduced in the state legislature that same month, requiring banks to flag and report unusual transactions for customers over 80 to a designated elder protection unit and to require notarizations for property transfers to be accompanied by an independent cognitive assessment when certain red flags were present. I testified before the Senate Judiciary Committee on September 10, 2025, where I played two short, carefully redacted clips the court had permitted for educational use. The clips were embargoed from public release, but they were offered as examples of how ordinary domestic scenes can signal extraordinary vulnerability. My testimony was practical and chronological. I traced the timeline from July 2022 to the conservator's appointment to the court's June 2, 2025 order and urged legislators to consider small, feasible rules that could interrupt similar harms early. There was resistance. Some notaries and private transactions groups feared overregulation. Banks worried about reporting burdens. Yet the committee's minutes show that the testimony, together with advocacy by the statewide elder group and the bank's own revision to its policy, nudged bipartisan support for a pilot program. The pilot was modest, a voluntary verification system launched in 5 counties beginning January 1, 2026, that required in-person verification and a notification mechanism for large transfers involving octogenarian account holders. That program's design, in the committee's draft, cited our case as a motivating example if not as a template. In the accompanying memorandum the legislative aide wrote, in careful bureaucratic prose, that the camera footage had introduced an evidentiary clarity that policy alone rarely achieves. Back at the House, the camera's role shifted again during the closing process. The conservator, following the judge's order, exported a curated selection of clips to a secure server and provided access tokens to the Elder Advocacy Group, the bank's training department, and a local law school working on a clinical elder justice project. Each transfer required redaction, release forms, and a data retention policy. The clips would be kept for 5 years, only accessible to accredited professionals, and would be purged thereafter unless further consent were given. There were debates about whether the footage should be preserved in a community archive. My mother, lucid in brief moments and bewildered in others, consented to educational use that she said might help someone else not to make our mistakes. Her consent, recorded in the conservator's file on July 23, 2025, felt like an act of civic generosity and also like a bittersweet recognition. She was willingly offering up privacy to produce public caution. The matter of intimacy and evidence continued to trouble me. I found myself, on some nights, watching the earlier clips where Evan knelt by my mother's bedside reading old letters and thinking that the footage contained salvations as well as harm. Those earlier tapes complicated any tidy moral narrative. In October 2025, an academic symposium on surveillance and domestic life invited me to speak alongside a sociologist who had studied family recordings and a historian who traced the rise of home cameras to the 1990s. We discussed chronology, how technologies arrive, how social practices adapt, and how law often lags behind. The recorded domesticity in our case, the historian argued, should be read as a document that reveals the changing scripts families use to care for elders, sometimes well and sometimes poorly. I agreed but pressed the point that the technology had been a last resort tool for accountability in a context where other institutions, banks, medical practices, neighbors, had not recognized elders' vulnerability with sufficient speed. There were, too, quieter reckonings about narrative ownership. Some relatives objected to the use of footage in trainings until they understood the redaction protocols. Others wanted more access because the tapes were, to them, a form of family record. I negotiated these tensions by adopting a principle that felt both modest and firm. Footage that served purely private memory without forensic or pedagogical value should be treated as family archive and shared only by consent. Footage that could prevent harm to others or instruct professionals could be shared under strict privacy and redaction standards. That principle guided the conservator's decisions and provided a template we published, with the Elder Advocacy Group, as part of a toolkit in November 2025. The toolkit recommended checklists for professionals and consent language for families, and it acknowledged the particularity of my case while urging generalizable practice. The financial dispersal, finally adjudicated in September 2025, followed the county's intestacy and will provisions. The conservator's petitions were granted in full, conservatorship expenses and the costs of the sale were paid from the proceeds, my mother's ongoing assisted living costs for the foreseeable 18 months were secured, and what remained was set to be distributed under court order. Those distributions were not simply about money, they were administrative acts that reoriented relationships. When the final accounting appeared in the docket on September 15, 2025, the document felt, at once, like an ending and a beginning. There were receipts for long-forgotten bills, for a new roof section paid in July, for an antique dresser, my father's, transported to a niece who had insisted it remain in the family. The court closed the estate on October 1, 2025, but it left open a small reserve to cover any unexpected claims for 6 months thereafter. After the sale and the final orders, the house's cameras were disconnected in stages. The porch camera, which had recorded the original disputed visit, was archived with the Elder Advocacy Group for training purposes. The indoor cameras were unplugged, their data exported, redacted, and then backed up on an encrypted drive that the conservator and I kept in separate fireproof safes. Unplugging them felt oddly ceremonial, a dimming of constant witness that had both saved and altered our family. The new owners, a couple from the school district, requested that the conservator leave behind a set of maintenance manuals and the home's original architectural drawings. They asked also, with curiosity, about the history evident in the grain of the floors and the worn banister. We met them on a bright October morning and handed over keys and a packet that included a single, heavily redacted image, an exterior shot of the porch on a summer day, so they might understand their new home's history without inheriting its burdens. There were lingering social consequences. Some relatives continued to keep a distance. Others, having seen how the legal process had unfolded, attempted careful rapprochement. Evan, complying with the restitution agreement, made payments through the conservator's account until September 2026, while continuing his sessions with the support group. He never reclaimed the house and rarely spoke publicly about the case. In family gatherings he arrived late and left early, a silent figure trying, in his own way, to live within the constraints restitution imposed. For my mother, the assisted living provided a quiet routine punctuated by brief phone calls that now came from a number with limited permissions. She sometimes asked, in moments of clarity, about the house, about the porch and the grapevine she had planted in 1987, and I described it to her with the particularity that memory requires. The cameras had recorded so much, describing the house to her required different work, memory that was not evidence but presence. As I write this chronology into the deeper record of our lives, I remain attentive to what the camera did and did not do. It created a ledger that was admissible, shareable, and pedagogical. It catalyzed policy conversations and modest legislative innovations. It recorded tenderness alongside manipulation. It did not, however, repair the private intimacies that had been frayed. It was not a substitute for the slow, conversational labor that relationship repair requires. The case became a small, local history, cited in a county report in November 2025, discussed in a law school clinical class that winter, and memorialized in a brief oral history segment at the local historical society the following spring. In all of those venues the chronology mattered. The sequence of July 2022 missteps, the October 2022 court order, the conservatorship, the sale in August 2025, because it allowed others to see how actions compounded and how institutions might interpose earlier. I continue, even now, to think about the ethics of keeping a home under surveillance and the responsibilities that follow when one does. There is no simple rule to navigate that terrain. There are, instead, practices that need cultivation, transparency with family, strict data handling protocols, engagement with community resources, and a willingness to place the footage into a public pedagogical register when it can prevent harm. The cameras in our case became an odd kind of civic object, a domestic technology that, when combined with public institutions, produced both accountability and further social unraveling. My task has been to steward those consequences responsibly, to ensure the footage is used to teach and not to humiliate, to allow my mother the dignity she wished for, and to make sure that the procedural history we created can inform a modest but practical set of reforms that might prevent another family from needing to invent such measures in the heat of crisis. The work is not done. The legal reserve will remain open through March 2026 to account for late claims. The pilot bank verification program will roll out in January 2026 and require monitoring, and the conservator's final reporting obligations will continue until the statute of limitations for probate claims has run. The cameras, archival now and no longer live in the house, remain a part of that continuing sequence of obligations and possibilities, and I intend to keep them available to those who can turn their images into prevention rather than spectacle. After March 2026, the procedural calendar that had defined so much of our family's life finally moved toward quieter entries. The small reserve the court kept for late claims drew to a close on April 1, 2026 with no additional petitions lodged. The conservator filed a supplemental closing report on April 20, 2026, accounting for the last invoices and recording the transfer of the encrypted drives to the stewardship arrangement we had agreed upon. That filing, dated and docketed, formally ended the court's direct control of the estate, though my obligations as a steward of the camera material and the conservator's lingering paperwork kept the story from feeling over. The statute of limitations for probate claims, in our jurisdiction, runs in a way that left no further open avenues by late spring, and so the legal perimeter of the case contracted to administrative aftercare and outreach rather than fresh litigation. The pilot bank verification program that had been slated to roll out in January 2026 did so on schedule. The participating branch in our county began offering the enhanced verification package for account holders over 80 and for transfers exceeding a threshold, $10,000 in the pilot design. The monitoring committee convened by the county produced an interim evaluation on July 15, 2026. Their report, which again cited our case as a motivating example, recommended 3 modest but consequential changes: tighter audit trails on staff-initiated transactions, a mandatory cooling period for non-standard transfers when requested by an account holder or relative, and the creation of an incident review board with elder advocacy representation. Those recommendations were adopted by the pilot bank by October 2026 and were proposed as amendments in the county's financial services guidance by the end of that year. The educational uses of the footage slowly took shape under the principles we had published with the Elder Advocacy Group in November 2025. In March 2026, the law school clinic released a case study that relied on redacted stills and timeline reconstruction rather than continuous video. In June, a workshop for social workers used 2 anonymized clips to illustrate nonviolent coercion in financial relationships. My mother's consent of July 23, 2025, that brief lucid moment when she said the footage might help someone else, continued to guide decisions. When a niece requested access to a handful of indoor clips in August 2026, for the narrow purpose of preserving family memory relating to my father's funeral and the dresser she had kept, the conservator and I facilitated a transfer that respected the toolkit's redaction protocols and the 5-year retention policy. That release felt consonant with the principle I had adopted. Private memory material remains family domain when it serves no forensic or pedagogical need. Material useful to prevent harm enters a guarded teaching register. The social arc of the family continued to bend awkwardly toward repair.